As a veteran who is service-connected and a lawyer who has been representing veterans for over 20 years, there are things that I see over and over again. Number one, veterans don't clearly ask for what they want. In the Army, we had an acronym known as BLUF, bottom line, up front, and that was part of the Army writing style. And you have to understand that the VA decisions are made by humans at the VA who look at several claims every single day. And we see a lot of cases where all of the evidence and all of the information was in the file, but it was hard for the VA to find or understand, and the claim was erroneously denied or the veteran was underrated. Mistake number two, make it hard for the VA to find supporting evidence. The veteran may say something like, I was injured in service, but they don't provide the when, the where, or the how, and they just dump a bunch of records onto the VA. However, even being highly organized does not guarantee a claim will be granted. In fact, I saw one file where a veteran had highlighted important stuff in yellow, underlined it in black, and circled it in red, and he was still denied. Mistake number three, making the rater guess. What's the connection between the veteran's back disability and military service? Now, the veteran knows that he's rocked hundreds of marches, humped the 240 Bravo, and every veteran knows what he's done, but if the veteran doesn't spell it out for the VA is not going to know. The VA needs to understand the connection between the military service and the current injury. Sure, the veteran knows the connection, and so does everybody in the unit. But if the veteran doesn't say it, and it's not in a medical opinion, how does the VA know? Number four, whining doesn't win. Some veterans feel that their last exam was inadequate. At the compensation and pension exam, the doctor didn't even look at the injury. Document that. That may be important. And the veteran can put that information in an appeal or a notice of disagreement, but a long-winded attack on the character of the VA employee who adjudicated the claim may just muddy the water. The key for success is often relevant and concise information, not attacks. Number five, relying on the VA's duty to assist the veteran. Yes, the VA has a duty to assist the veteran, but sometimes veterans get denied because they assume the VA already has specific evidence or information, or that they will look into something without any guidance. The veteran can make it easier for the VA by providing information and documentation needed to prove either service connection or the severity of the disability. Number six, an injury in service does not automatically result in service connection. The veteran needs to demonstrate both a current disability and evidence that that injury occurred in service or was aggravated by military service. Mistake number seven, assuming that receiving care at a VA hospital will automatically result in service connection. No, the VA Medical Center and the VA Regional Office are not the same. Just because the VA Medical Center treated a veteran for a specific injury does not mean the VA Regional Office will service connect the veteran for that disability. Number eight, veterans fail to file claims for secondary service connection. For example, Susie, an airborne soldier, injures her right knee in a jump. This is a well-documented injury, and it's documented throughout her service. After getting her DD-214, Susie begins to notice that her right ankle, which is attached to her right knee, is having problems. Soon that affects her hip, and she has to have surgery on her right hip. Now the hip that is connected to the knee, that is connected to the ankle, are all causing the problems. But Susie only filed a claim for her right knee because that was the only injury that was documented in service. No, Susie has the right to file for secondary service connection for all of the other problems caused by that injured knee. Now, it's important to note that just because Susie thinks her ankle and hip were caused by the right knee, that's not going to be enough. But if Susie's doctor says, yes, these are all secondary, then that is going to give Susie a basis for the secondary service claim. Number nine, not appealing an incorrect VA decision. Veterans have the right to appeal, and the rating decision tells the veteran why the VA denied the claim. There are two problems that occur when veterans don't appeal. First, if they later refile the claim, they will lose potential back pay. And second, in order to refile that claim at a later date, the veteran must provide new and relevant evidence for that claim. This means the veteran can't just submit the same claim with the same evidence, or the VA may say that that claim has already been adjudicated.